Today, there was a hearing in the Karen Reed case, mostly dedicated to the defense's motions to strike some of the Commonwealth's experts. Right now, from what we know, there's a number of experts that the Commonwealth's going to be calling the biomechanical engineer, but there's also, they want to call Dr. Crosby, they want to call Robert Gilman. Dr. Crosby is a dog bite expert that they want to testify in rebuttal to Dr. Marie Russell, that actually these injuries to John O'Keefe's arms are not consistent with a dog attack. And then they also going to want to call a Robert Gilman, a meteorologist, who's going to testify about how hard the ground was, which potentially John O'Keefe fell on, which could have caused the blunt force trauma to the back of his head. So these are the two experts that were the focus of today's motions. Before we jump into what happened today, and it was definitely very interesting, I want to remind everybody that actually there's a change in schedule. Tomorrow, there is going to be a hearing also in the Karen Reed case. There's going to be actually two hearings. One of them is the federal appeal, the federal habeas corpus appeal, which was filed with respect to the double jeopardy issue. And then they're going to come back to the state court, to Judge Cannoni's courtroom, and argue the motion to dismiss. So there's some questions about when this motion to dismiss was going to be argued. Well, it is going to be argued tomorrow. It's right now scheduled for 11 o'clock in the morning, but if the defense finishes at the federal courthouse earlier, then they'll come earlier. So you got to keep watch of the live streams that are going to occur. You can definitely join us tomorrow here at Brother Counsel Studios. I'm going to be watching the streams, and as soon as it goes live, I'm going to go live, and we are going to be live streaming it and giving you my analysis on what's going on. So this motion to dismiss hearing tomorrow, March 5th, slated to begin at 11 a.m., may start before then, but definitely join us for that hearing. So now let's get into what happened today. And the first thing that happened is Judge Cannoni took the bench. And we know, as I've already pointed out to you, that this is going to be happening much more often now, that each attorney feels much more under the gun. It's going to be the question of who did what, who said what, who knew what. So that's why we're finding that Elizabeth Little just filed this statement of clarification that she was the one who filed this specific pleading that we're going to be talking about in a minute, and therefore she herself wants to clarify it. And this is a way that each person is trying to only take responsibility for what they did. Now, Judge Cannoni first said, as soon as she came onto the bench, she said she wants every attorney to realize that really each attorney is legally accountable for the actions and the statements for the entire defense team. So if everybody is signed on a document, that means that you are all taking responsibility for that pleading. And therefore, stop with the finger pointing. Everyone shouldn't get up there and say, I did this, I did that, she did this, he did that. Don't start with that. If one person is making a statement, it's on behalf of the entire defense team, and it's imputed on the entire defense team. Okay, so she wanted to make that clear. Now, whether that's actually accurate, we're going to talk about in just 1 minute. But before that, let's see what she says. So then she pulled up this pleading in which Elizabeth Little actually filed a statement of clarification about, and she wanted to get some more clarification about this specific pleading. So let's pull this pleading up, because again, remember, Robert Alessi was the one who talked mostly at the last hearing where this whole issue came up about the misrepresentations in court. So her questions were directed to Robert Alessi, but let's see what it's about. So let me just pull this up. Okay. So this was the opposition, this defendant Karen Reed's opposition to the Commonwealth's motion to exclude the employees of ARCA. And this is where it starts. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. This was the statement that Elizabeth Little wanted to clarify, that actually we did pay these experts, and we paid them in July of 2024. And this is a filing that happened in February 16th, 2025. So obviously you knew that you paid them. So this definitely looks like you're misrepresenting something to the court by saying that you did not pay for these, you were not hired or paid for by the defense. So Elizabeth Little wanted to clarify that with her previous filing that we talked about yesterday, and that was, well, we just meant here that they were not hired or paid for by the defense in undertaking the reconstruction and in coming to their conclusions. But yes, we did pay eventually at the end of trial for their time, and only, of course, after the U.S. Attorney's Office said that we could pay them. So that's what she wanted to clarify. Again, like I said yesterday, not a good look. It's not great when you put this broad statement in a motion and then you're trying to explain it and say, well, we didn't mean this, we meant that. Okay, but then Judge Cannoni actually moved on to another part of this motion, because if that's what you're presenting, that this is really everything's up on the up and up, and you didn't clarify, and you should have been more specific. Well, then take a look at this next part of the response. And this is what she quoted in court. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARC Act witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. So this seems to be saying that we turned over everything. And Judge Cannone said, well, did you turn over that invoice? Did you turn over that invoice when you wrote this? And now you're saying that we turned over everything that was in our control. We turned over everything. And again, she said, Robert Alessi, you are signed on this. So if you're signed on it, you can't just point the finger at Elizabeth Little and say, well, she was the one who wrote it, so I don't know anything about it. So what are you going to do about that? So that was how she started off the hearing today. Okay, not exactly what anybody was expecting. That's why you always got to watch these hearings, because there's always something that's unexpected, some sort of curveball that's being thrown in. So what Robert Alessi responded was the following. He said, Your Honor, I have to take issue with what you said, specifically that each attorney is responsible or accountable or legally accountable for the actions and statements by the entire team. Meaning that there's two different rules in which to analyze an attorney's conduct on a case. One of them is with regular rules of criminal procedure and case law and the rules that govern the court. That's just the rules that you have to abide by when you are acting in a certain court. Just the court rules, the criminal procedure rules, the case law, things like that. Now that he said, I agree with you. I can completely take full responsibility for anything that my name appears on, and anybody that said anything on the defense team. Yes, I understand. I agree with you that ultimately I take responsibility for that, but only as it relates to legal arguments and only as it relates to legal actions taken on a case. But when it comes to professional responsibility, when it comes to in each individual attorney's candor to the court, that's where I take issue with you. That's where I don't agree with you, Judge Cannone, that because another attorney that is on the defense team makes a misrepresentation, that I am responsible in making sure that every single thing that attorney says and knows, I also know, and therefore I can correct any misrepresentation. That's not true. And I have to say that I agree with Robert Alessi with this specific point. When it comes to the rules of professional conduct, that's where you look at each individual attorney's conduct, unless there are a few exceptions. Okay, from my research, some of the exceptions are the following. If you have a direct supervisory role over an attorney, so you get a new attorney into the office, you're the senior attorney, and everything that attorney is doing in the beginning is under your direct supervision, and then that attorney goes and makes a misrepresentation in court, you have to be on top of that attorney. So there's much more of a responsibility that you have if you are the direct supervisor of that young attorney who just got into your firm. That's when you have more of a responsibility what another attorney does when it comes to the rules of professional conduct. Another instance where you may be responsible for another attorney's actions is if you order that other attorney to do something or say something, or you ratify it, or you know about it. Okay, but it all comes back to what you knew. So unless you're a direct supervisor, which obviously no one is a direct supervisor of Alan Jackson, Robert Alessi is not the direct supervisor of Elizabeth Little. These are all very experienced attorneys. They don't really have a direct supervisor whose role is to supervise that attorney. Just because attorneys work together and one may have more experience doesn't mean that one is the supervisor and direct supervisor role over that attorney. So that is what he said, I believe, is the accurate recitation of the law. Okay, so when it comes to professional responsibility, when it comes to candor of the court, which obviously implicates pro hoc vice, then I disagree with you, Judge Cannone, that I'm responsible for everybody else, what everybody else says. And that I think is true. I think that's accurate. But when it comes to Rule 14, and you want to fashion a sanction for a discovery violation, and one of us represented something and really wasn't true, and therefore there's a discovery violation, you're right. That gets imputed onto the entire defense team. So that was something that he argued back with Judge Cannone, and I have to say that I agree with the way that Robert Alessi framed that specific issue. Okay, now let's move on to the motion. So the motion first that Robert Alessi argued was the motion to exclude Dr. Crosby. And he made some very strong arguments. Number one, he said he's not an MD. And Your Honor herself, Judge Cannone herself, said when they were talking about in the last trial, in the first trial with Dr. Rentschler, that she said, if you're not an MD, you can't opine about causation of an injury. Okay, so that was her own statement, and actually it was an accurate statement of the law. Generally speaking, from my research, the only person who's able to testify and opine about causation is an MD, a doctor. Or when it comes to dog bites, then you do also find that veterinarians or forensic odontologists, they can also testify about causation, specifically when it comes to a dog injury, a dog bite, things like that. But outside those specialties, you don't find that you are allowed to testify about causation. And Dr. Crosby, he may call himself a doctor, but he's not really a medical doctor. And he's not a veterinarian, and he's not a forensic odontologist. So therefore, number one, his argument is that he's not qualified. And remember, there's two prongs that you have to analyze when you're arguing against an expert being admitted. Number one is the person qualified? And here the first argument is that he's not qualified even. So we don't have to get to his methodology, but he's not qualified. He's not a doctor and veterinarian, forensic odontologist, therefore he's not allowed to testify. Now, he said that what Dr. Crosby tried to do here is he tried to say that, well, doctors can talk about treatment. And I'm agreeing that I'm not going to talk about the treatment of wounds. Yeah, I'm going to leave that in the safe hands of doctors who are qualified. But in terms of what inflicted wounds, I am allowed to testify that, and you don't need to be an MD. So he said that Robert Alessi argued that that's not true. That's just, he made up this straw man, which is completely untrue, and there's no case law about that either, by the way. So that's a good try, but it's not going to work. What Dr. Crosby is a certified behavior consultant. So he knows about the behaviors of dogs. He knows when dogs are acting aggressive and when they're not acting aggressive, and what they do when they act aggressive and things like that. But to actually opine about injuries on a human inflicted or caused by a dog, he's just not qualified. Then he moved on to methodology. What's his methodology? Well, what he did was he took measurements of Chloe, purportedly, and then he applied it to pictures on John O'Keefe's arms. So he took the molds, took these measurements, and then he tried to apply it, and then he came to the conclusion that it couldn't have been Chloe, number one, and it couldn't have been any dog. No dog ever would have inflicted these type of wounds on John O'Keefe. And he also said that actually the cause is a sharp object. So that is what he decided is the diagnosis. And again, Robert Alessi said, that seems to me like a diagnosis. He's trying to diagnose that this is from a sharp object. He has no experience, he argues. He has no experience in doing any of this in terms of causation. And then he said that one of the things that he used was a hospital wristband to use measurements. Because obviously he can't get the body anymore, John O'Keefe. So he used some of the pictures and used a hospital wristband for measurements. And there is this methodology that he's using has not been accepted by the scientific community. There's no evidence of that at all in the papers. He's not relying on any study or publication that was been peer-reviewed. And then he argues that there is some sort of overlay method that he tried to argue that he used. And he said, actually, this is what Robert Alessi argued, that actually using the overlay method, what that entails is that you have to get a mold of the dog, and then you need to apply the mold by making a model of the injury and of the arm. That's what if you want to use the overlay method, you can't use pictures. That's not how this works. There's no methodology that says that you can use pictures when it comes to the overlay method. So also he said that when you research the overlay method, the only people that are qualified to do that overlay method is forensic odontologists. And we already know that when it comes to forensic odontology, which is what Lally already established in the previous trial, is that it's not a reliable science in terms of matching specific dogs with specific injuries. So even if you're going to want to say that maybe that is a good science, but that's only by forensic odontologists, which Dr. Crosby is not. And the overlay method that he tried to say that he used was not accurate. And then he moved on to some of the issues that Dr. Russell had with Dr. Crosby's conclusions. And that is that Dr. Crosby treated this, when I say treated, I mean, he looked at this arm as though it was static. And when the dog was attacking the arm, it's as if the arm was just sitting in one place, allowing the person, imagine a person getting attacked by a dog, just allowing the dog to attack your arm without moving it at all. So that's how Dr. Crosby treated And as I say treated, I mean looked at this scenario. That's how he analyzed this scenario and analyzed the pictures, which is obviously incorrect. If this was an attack by a dog, well, most of the time you're going to be trying to fight with the dog and try to get the dog off your arm. You're going to be moving your arm a lot. The skin's going to be moving, and it's not static. So he doesn't account for any of that. Also, some of the photos that he used were blurry, and he didn't account for pinching and dimpling and other issues that the arm can create because of its anatomy and things like that he has no idea about because he's not a doctor. Now, also, he cited Dr. Crosby to some theses that he wrote. Now, he wrote two theses, a master's thesis and a PhD thesis. Now, in the master thesis, it's very clear that the methodology that he's purporting to use in this case does not appear. So if you want to cite to your thesis that, oh, you see that my methodology is sound because I wrote a paper about this, which was peer-reviewed and accepted for articles, well, there's no methodology that you're using from that paper into what you're doing today. So that was another argument that he made, that even the thesis that he quotes doesn't even say anything about his methodology. And then he also said something interesting that he found in that thesis itself is that bite marks can be generally defined as a pattern. Remember how much Brennan hated that, oh, how can you just look at everything and say it's a pattern? What about each individual wound? And Dr. Russell kept saying, well, of course, you don't look at each individual wound. You look at a pattern. That's what you do. You look at a pattern. That's what you do in medicine. You don't just look at one individual thing and not look at anything else. You look at it in a vacuum. You have to look at the pattern. So, and this is their expert, Dr. Crosby, is saying, yeah, even in his thesis, he says that is makes sense for bite marks. And then he says that you can even look at his PhD thesis. His PhD thesis, which, by the way, he also said that generally speaking, you should be working with a medical examiner, which he was not. But in the PhD thesis, also, he doesn't say anything about the methodology that he's purporting to use in this case. And somehow he's creating this methodology. So he's to his papers, he's citing to his theses, and in the theses, it doesn't even talk about his methodology, even in the PhD thesis. So then he also talks about some degree that he has in veterinary science, which he's never familiar with. He never come across that, and neither is Dr. Russell. What is this degree in veterinary science? You're not a veterinarian, so what are you exactly? Some degree in veterinary science. He says no one knows what that is. And he says, really, Dr. Crosby was a police officer. He started off as a police officer for many years, so he's a police officer. And now, after he's done with being a police officer, he got into dog bite stuff. So he's doing that now. And then he made an interesting argument. He said, if Your Honor thought that this was a close call for Dr. Russell, who has 30 years as an experience as an emergency medicine physician and 30 years or close to that as a forensic examiner or forensic pathologist, well, this shouldn't even be a close call at all. He's just completely not qualified at all to testify about that. So the first thing that the judge said right away that was the end of Robert Alessi's presentation. And then before Brennan got up, the judge said to Brennan, well, let's just get one thing clear. He's not going to testify that this was a sharp object, right? That's not what he's going to testify about, right? And Brennan said, yeah, I'm not going to ask him about that. So that's clear. That's completely off. He's not allowed to say that this was a sharp object as opposed to anything else. Okay. But then Brennan got up and he said, well, he's testified in many other courts before, state and federal courts. He did rely on a number of books and journals. Oh, by the way, also something Robert Alessi says that there's no footnotes, there's no references to any specific materials that he talks about. I'm going to get a little bit more in his response. But Brennan gets up and he says, yeah, well, he did rely on some books and some journals, and he has participated in the past in autopsies, and he's been recognized, throughout the world as this expert, throughout the country as an expert. He's testified many times before. Okay, that's essentially what he argued. And then Robert Alessi got back and he says, he may have testified in a dozen state courts and federal courts. It doesn't really matter. The question is, what did he testify about? Did he testify about causation? Is that what he testified about? That's what he was admitted as an expert to talk about? Or was he talking about behavior of a dog? Okay, maybe that's his expertise, behavior of a dog. But if you've never been allowed in any sort of courts to testify about causation, well then, it doesn't matter how many times you testified in court. That doesn't do anything. Now, also something else that he said is that if you look at his report himself, you look at Dr. Crosby's report, he cites to all these different journals and books and studies, and he says that all of these references may have affected his opinion. So Robert Alessi says, what does that mean? May have affected your opinion. We want to know what affected your opinion. We want to know what methodology you can point to, which actually guided you in coming to your conclusion, well, this may have done it. What part of that may have done it? Like that's completely vague and ambiguous, and that doesn't satisfy the requirements of Daubert. So again, he stressed again that the methodology is completely unsound. It's an orphan methodology, and therefore he should not be allowed. And then Brennan got up again and basically just attacked Dr. Russell. I mean, like that's basically what he did. So Brennan really didn't have any good responses to Alessi. And I mean, objectively speaking, he just didn't respond to all these arguments that Alessi was saying. Yes, he's testified in other courts. Okay, great. He relied on some books and journals that he cited to, but whenever you look at those books and journals, you can't identify the specific methodology in which he used in this case. That's what you have to do. And that's what Dr. Russell did. She pointed specifically to studies about pattern recognition analysis, and that's exactly what she used in this case. So when you don't do that, then you shouldn't be admitted as an expert. So that was what happened with the first argument about Dr. Crosby. Then he moved on to Robert Gilman. Now, Robert Gilman is a meteorologist, and the meteorologist, he said, is very clear, cannot testify about the hardness of a ground. Yes, he can testify about precipitation and weather patterns and how much snow there was and whether it's a blizzard or not, but he just simply can't testify about the ground. When you want to talk about the ground and soil and freeze and thaw processes, you have to get an expert about that. There are specific areas or specific fields where people can talk about these things about the ground, not a meteorologist. And in fact, really, which is probably the winning argument for Alessi on this, is that his ultimate conclusion is that the ground was hard as a rock. That was what's written in his report. That's quote, hard as a rock. What type of scientific explanation is that? Hard as a rock. Like I said before, like, okay, so what's the stage right before hard of a rock? A little bit less than hard of a rock? And what's the stage right before that? I mean, like you're not using scientific terms even. You're using layman terms. So you're gonna trot this guy out in front of a jury and say this guy's the expert, and he's gonna say, yeah, it's hard as a rock. I mean, that's how regular people talk. So that's also terms. He also said that he also has no methodology at all identified how we can determine that the ground is hard as a rock. And then he also said, one of the things that you can use is common sense. Common sense. When you hear a meteorologist talk about the weather, do you ever hear a meteorologist say, this like caused me to chuckle, but do you ever hear a meteorologist say, oh, today's going to be 20 degrees below zero, and the ground is going to be really hard as a rock? You never hear a meteorologist talk like that. That's just not how people talk. That's not how meteorologists talk even. And they talk about the weather. They talk about how much snow there's going to be, how much ice there's going to be, what the degrees are going to be, what the weather patterns look like. They don't talk about the ground because they can't. It's not in their expertise. So you can also use your common sense to realize that a meteorologist cannot testify about the hardness of a ground. And then Brennan said, I'm not sure if I'm going to talk to him about how hard the ground is or how hard it was, if it was hard as a rock. So Brennan kind of conceded to that point. And he says, well, I just want him to talk about that the ground, that the ground was freezing. And even on that issue, Robert Alessi, rightfully so, got up and said, he can't talk about ground. Sorry. The ground is out of his expertise. He can talk about weather. He can talk about precipitation. He can talk about how much snowfall there was and how much icy conditions it was. But he just simply, once it gets to the ground, you can't talk about how frozen the ground may have been. That's just simply out of your expertise. So Judge Cannoni took this under advisement. So my only critique for Robert Alessi in this case was that I did a little bit of research on this, and I didn't find any sort of case that says that a meteorologist can talk about the hardness of the ground, or that anyone who's not a veterinarian or a medical doctor or a forensic odontologist can testify about causation of a dog bite. There is simply no case that I found that says that these experts can testify. So if this is the Commonwealth's burden, they have the burden to produce a case or cite to a case or show the court why, under Massachusetts law, these experts do have the expertise to testify in these matters, in this substance. So it's clear to me, it seems pretty clear to me that these experts should not testify. There shouldn't even be a Daubert hearing, I believe, because it's so clear that they were not using the correct methodology or any methodology that's been recognized by the scientific community or the relevant community that they purport to be from. So it was pretty clear to me, I think, that Robert Alessi really just won the day in terms of this specific argument. So these experts, in my view, should be struck. They should not be allowed to testify, and there shouldn't even be a Daubert hearing to clarify that. So to me, that was pretty clear to me, but you never know what Judge Cannoni is going to do. All right. Then it moved on to the Commonwealth's motion for sanctions. And this is in respect to a text message. Really, I mean, there's apparently two different reasons for this motion for sanctions. One of them, which I saw in the brief, was the fact that David Yannetti talked about a text message which Proctor sent to Adam Lally at the conclusion of last trial about whether he watched the closing arguments. And Proctor said in that text message that he didn't watch the I'm not quoting it verbatim, he didn't watch the closing arguments, and he said he had some words for Alan Jackson that obviously were not complimentary. So that's what he quoted in his papers. That's what David Yannetti quoted. Now, there was a protective order that any of those communications are not to be disseminated to the public. So Yannetti slipped up. And therefore, Brennan argued that therefore that you need to impose sanctions on the defense. And his sanctions, and by the way, during this argument, he also argued something about Elizabeth Little, saying something about a federal investigation. And he said very clearly on the record today, which is, I guess, what we were waiting for from the last hearing. He said on the record today that the federal investigation is absolutely over. It's closed. It's done. They were contacted by the U.S. Attorney's Office to let them know, and they could publicize it in their name, that the federal investigation into this investigation is over. It's closed. So there's nothing to see here. Now, like I've spoken about before, if you were completely sold on the conspiracy, then this is going to be a blow to you. But if you're just looking at this case from the standpoint of, does the evidence actually prove that Karen Reed killed John O'Keefe, and committed this murder, if you just focus on that, the evidence all remains the same. And therefore, there's just simply not enough evidence, as we sit here today, to convict Karen Reed. And that's why she still should have been acquitted, whether it's a conspiracy or not. So like I said, I never sunk my teeth into the conspiracy in the first place. I think it was a mistake by the defense to concentrate on it so much. And really, their approach should be, and then most likely is going to be in the second case, that there's not this grand conspiracy, but there's a lot of questionable activity, a lot of turning the other eye, and a lot of sloppy investigation, which just shows you, and preferential treatment, by the way, which just shows you that this investigation was just done sloppy, and certain people were protected from the investigation, and that's why we just don't know what happened in this case, whether Karen Reed actually did this or not. So, and since you don't know, you cannot convict Karen Reed. But again, we'll see what happens in the second trial. There could be a lot of evidence that will be presented that we didn't see in the first trial, so we'll kind of wait for that to happen. Okay, so that was Brennan's argument that there should be sanctions. And what he was arguing was for, what should the sanction be? Well, he argued that there should be a gag order for all the attorneys. None of the attorneys should be allowed to talk about this case in any forum. And all motions, and not Karen Reed. Karen Reed can talk as much as she wants. That's what he said. He's happy to have Karen Reed talk as much as she wants. And also, which is the biggest part about this motion, which is going to hurt all of us covering this case, is that he wants all motions filed under seal now, which means that we cannot see those motions until it gets the okay by the Commonwealth and the judge to disseminate it to the public. Now, this can obviously cause a major delay in the filings and us getting the filings to be able to analyze them. And who knows if these already been hearings and rulings on these motions when they get released to the public. So, that would really hurt all of us over here covering this case to not see the filings and be able to explain the filings so that the public actually knows what's going on in this case. So that hopefully will not get granted, but that's what he's moving the Judge Cannoni to do in this case. Now, Yannetti got up and he was very soft-spoken, and he said very clearly, I made a mistake. I should not have put that text message in the pleading. I should not have said it. I did, I guess, technically violate the protective order, but it was not intentional. There was no willful here. And you see that my attempts to protect identities, because he was talking about a juvenile, John O'Keefe's nephew, in that same pleading, and he kept it very confidential just by using just PF, whatever. So that is therefore he's arguing that it wasn't intentional. And when it comes to sanctions, when I was talking about in the live stream, when it comes to sanctions, it really depends on the attorney's conduct and their pattern or practice. Like, is this the first time? Was it intentional? All that the judge should take into consideration before they issue any sort of sanctions. So that is something that he's saying very clearly, that, look, this was one mistake that I've made, and therefore, don't sanction us. Now, he also said that there's three main reasons that the Commonwealth wants to sanction us. Number one is privacy, safety, and the integrity of the investigation. So he said, as the terms, if you take each one individually, think about each one. Privacy, Well, everybody knows Trooper Proctor in this case, and everybody has opinions about him already based on the text messages that he already read in open court in the first trial. So in terms of privacy, there's nothing really more that people are going to say, oh, wow, I never knew that about Trooper Proctor. Number two is that everybody also knows about Trooper Proctor's opinions about the attorneys on this case and his opinions of Karen Reed. He already said that very clearly in the last trial. Now, although he was only talking about David Yannetti on this case, how he hates him and other things that he said in his testimony, he never specifically spoke about Alan Jackson, but you can kind of understand what his feelings would be towards Alan Jackson. They probably wouldn't be so complimentary. So, in terms of that, privacy, there's no issue there really either. In terms of safety, he said, again, everybody knows Trooper Proctor already from the first trial. There's nothing more that this text message is going to make Trooper Proctor's life any more unsafe than already was before. So there's really nothing there either. And in terms of the integrity of any investigations that are going on, there's no other investigations that are going on with Alan Jackson's clients that Trooper Proctor has anything to do with. So there's no questions about integrity of the investigation. So he said that these three concerns by the Commonwealth, which is why they're asking the judge to impose sanctions, are really not relevant anyway. Nevertheless, again, there was a violation of the protective order, and therefore the judge could sanction the defense in this case. And I do see, by the way, I could see Judge Cannone saying, you know what, just until trial, we're ready a couple weeks before trial, just to be sure we're not going to release anything to the public until we all sign off on it. So that may be the case, and that will obviously hurt us very much. But that's that. Now, there was also some other arguments about the disclosure of federal grand jury transcripts. I'm not aware of this. I don't know which transcript Yannetti was talking about or Brennan was talking about, and which transcript was released to the public. I'm not exactly sure, but there was a big sidebar about it, a long sidebar about it, because it wasn't something they're going to argue about in open court, and therefore I can't tell you much more about what happened there. Now, there was also something that he wanted to clarify, was that when Elizabeth Little spoke about an ongoing investigation, you have to understand the timeline here again, because Elizabeth Little said in court that there was an ongoing federal investigation, and the timeline is the following. On January 30th, 2025, there was a letter from the U.S. Attorney's Office saying that the investigation is ongoing. Okay, so January 30th, 2025, a letter from the U.S. Attorney's Office saying the investigation is ongoing. Okay, now, a few weeks later, February 18th, 2025, is when Elizabeth Little said the investigation is still ongoing, because they saw that letter and they didn't hear or see anything that would change that. And then what happens is right after February 18th, that's when Brennan got called to let them know that the federal investigation is over. So that's what Brennan said. Just to clarify, so February 18th, when Elizabeth Little said the investigation was ongoing, she didn't do anything wrong. That was her impression, and it was still ongoing until the next day when Brennan was called by the U.S. Attorney's Office to let him know that the investigation is over. And then February 20th is when he called David Yannetti to relay that information. Okay, so that is what happened in court today. But then at the end of court, that's when they're talking about some other motions that were filed about this case that they have to still argue. And one of them was the motion to amend the scheduling order to accommodate some additional discovery, that since additional discovery was just provided to the defense, well, they want some more time to sift through the discovery and maybe buff up their motion to dismiss. So remember, the motion to dismiss was filed already, but now that they got more discovery, 400 pages of documents or whatever, so now they got more discovery, more videos from that retired sergeant's computer. So now they want to say, hey, maybe there's some more information here that we can add to our motion to dismiss. So they're talking about that motion to amend the scheduling order so that they can have more time to file the motion to dismiss. To make a long story short, it seems that the videos, according to Lally, are the same exact videos that they already turned over. So there's nothing additional. There's no that 45 minutes or 42 minutes, however much minute that was missing, is all of a sudden recovered and is on this guy's computer. No, that's not the way it worked. There's nothing additional, it seems, from these new videos that they didn't already have. So if there's nothing new, well, then we can already argue this motion tomorrow. And that's essentially what happened. What happened was that the Judge Cannone and Alan Jackson and everyone was talking. They said, okay, we're going to just argue the motion tomorrow, which is March 5th, 2025, after they are done in federal court. That's what happened with that. Now, the motion for reconsideration. Remember, we talked about this yesterday in yesterday's video, the motion for reconsideration. That was the motion that these Sallyport videos that they already were provided to the defense, they did not want them to provide it in the way that they did. They wanted them to keep them on the computer and and do it in a forensically sound way. So there's a motion to reconsider that entire order, but you know what? It's too late because the Commonwealth already provided the videos. They already did everything that the court said that they should do, and therefore they're saying, look, I'm sorry, but too bad. We already did what we're supposed to do before the motion for reconsideration was filed. Now, Elizabeth Little did say that she sent these motion for reconsideration to the Commonwealth Sunday night, and the copying was done Monday morning. So it may look like, hey, as soon as you got this motion for reconsideration, you quickly did this, copied the video or drag and dropped whatever amount of video that you did, and so she was kind of like saying, come on, there's something going on there. You should have realized from the motion for reconsideration that you shouldn't have done anything. Nevertheless, they did provide the videos, and Elizabeth Little says that it's possible that there still is some metadata on the original device. So we still want our opportunity to see any metadata or download any metadata that has to do with those videos. So she still wants to argue that motion for reconsideration. So that motion is also going to be argued tomorrow. Now, also, there's a motion to strike or to have a Daubert hearing on the neurologist. There was a neurologist that was also an expert that the Commonwealth wants to bring in to testify in their case in chief. And the defense apparently filed a motion to exclude them. Now, I did not see that motion, and it seems that the judge didn't see that motion. So I don't know if this motion was filed, if there was an error there's a mistake there, but I didn't see this motion, but they're going to argue this motion tomorrow to strike this neurologist expert that the Commonwealth wants to call in their case as well. So we're going to have that also tomorrow. So big day tomorrow. Also, there's a big day today, as we just went through, but that was essentially what happened today. So again, like I said, I think that the experts, Dr. Crosby and Robert Gilman, should not be able to testify. It just doesn't seem that they, number one, have the qualifications to testify about the subject matter that they want to testify about. And also their methodology has not been peer reviewed, is not accepted by the scientific community in the methodology that they used, if they used any. And therefore, we'll see what happens with that. In terms of the sanctions, that also, I don't know, that's going to be a judgment call by Judge Cannoni. And for the benefit of all of us, I hope she does not grant the sanction, but you never know. And that would really hurt us all. So hopefully she will not grant that sanction, but you never know. So that's going to be it for now. If you haven't yet, please subscribe, like, and we'll see you tomorrow and around 10:30, 11 o'clock in the morning. Keep it here at Brother Counsel Studios, which we will be live streaming that motion hearing tomorrow. We'll see you all then.